ऐं उन खां पोइ जेको आहे असांजी टेरिटोरियल नेचर ऑफ लॉ चए स्टेट्स आर टेरिटोरियल एंड लॉ इज स्पोकन ऑफ is a being a territorial, but we have to distinguish between the territorial enforcement of law and the territoriality of law. Territorial enforcement of law means that in peacetime the law of a state is enforced within the territories of the state and it is the public ships and aircraft as well as on vessels and ships registered under it is law. This is the enforcement is confined to the boundaries of the state. In criminal law, this is reminded to some extent through the practice of extraction, and in civil cases, states give a remedy in their own courts. As compared to this, saying that law is a territorial nature means that a system of law belongs to a defined territory being applicable to all persons, things, acts, and events within their territories. And that it does not apply to person, acts, things, and events elsewhere. The basis for this is that a legal system belongs to define the territory, and its rules are not being applied or enforced extraterritorial, and also that other states don't regard them. It is pertinent to mention here that Islamic law, the world is divided in two spheres according to some school, while it is one of spheres according to others. The spheres are the Darul Harab territory of war and Darul Islam territory of peace. A person may not be prosecuted for committing an offence outside the Darul Islam. The reason advanced by the school who upload this division is that the protections of law is not available to the person outside the Darul Islam, and the Islamic State lacks the jurisdiction in enemy territory. The other schools of disagree. The general functions of law. The law is said to have the 5 functions as follows: to establish order in society when dispute arise. In all but the primitive societies, a system of law performs a social function that are essential to the maintenance of society itself. According to Al-Ghazali, the function of Islamic law is the protection and preservation of the 5 persons: Deen, life, family, intellect, and property. Art is called these the minimum content of natural law. If the law fails to achieve this goal, society will not able to survive. In other words, the function of law is the ordering and maintenance of society. This fact is recognized in all societies. If disputes are not resolved through the machinery of the law, they take so long that the rights of the parties are lost. Then matters may deteriorate into personal violence and private vigilance. The aggrieved parties will be forced to take the law into their own hands, this destroying the basic fabric of society. This would very well be the cause of what we usually term the law and order situation in Pakistan. All these justice is the key element. To affirm the social norms, that may have be violated. We state above that law is the structures of order norms that guide the conduct of individuals and institutions of society. A dispute arises when one party does not act in accordance with the expectations of other party. The matter then goes before a court which will decide it and reaffirm whether the now violated is or is not to be enforced to make the functioning of society more efficient. The law provides a framework within such a members of societies behave and interact with each other. For this function allow me to predict how others will behave and adjust their behavior accordingly. It brings efficiency into the functioning of the social system. For example, law performs an important function is regulating everyday vehicle traffic. Our new motor is an example. We will later study the economic analysis of law, where this idea has been carried to the extreme. To act as an instrument of social change and social engineering. The law helps not only to codify existing norms but to modify behavior, to remove moral and legal conception, and identify the emergence attitude, standards, and belief in rapidly changing society. Law may therefore be used to educate people. Some people have an argument that the provision of some law, especially those pertaining to hudud, should be applied only when society has been reformed and basic necessity have been met. The argument in wrong when we created the right of the suspension of law. If the argument is accepted, the entire Pakistan Penal Code should be scrapped. In other words, the application of law to reform to self through the education, to enforce justice according to law through the principle of rule of law. If the social order of society is to be maintained, the law must treat people equally, the governors and the governed, the rich and the poor, the content and the discontent. It is only then that the people will willingly accept the norms laid down and concretized by the law. This in reality that what we mean by rule of law. See also the sections on the normative factual side of legal system, who consequently a number of norms have been incorporated in the legal system ensure this, although the reality may sometimes deviate from the idea. This, however, is only the character aspect of justice. We have more to say about the other aspect of justice, which are very much the function of law in the next sections.